All right. Without further ado, we're very excited to have this panel, and I want to thank you all for showing up on a Friday afternoon to join us for this discussion. It's kind of an interesting discussion in which there are a lot of disagreements and agreements and puzzles, questions that are being raised. Our agenda is, well, one, this introduction. Um, Shout out to the person who's in here from Ole Miss and some of the other people who are law students who are here. And we have, like 250 people or something like that. So it's pretty exciting. We're going to do an ever so brief federal and state backdrop just for the people who need that. It's not going to be more than a couple of minutes. So if you're agonizing over that, just have a sip of coffee and wait for a second. Then we're going to do a discussion of San Francisco versus EPA and then get into the questions about the implications. And we've reserved a lot of time at the end for questions. And we're looking forward to those. I want to thank our co-sponsors here, the California State Association of Counties, the County Counsels Association, of which I'm a member, as well as the lead for the Environmental Law Section's study group. The environmental law section of the California Lawyers Association. I am a advisor to the executive committee for the environmental law section, and the California Association of Sanitation Agencies that are sponsoring this. A special thanks to CSAC for running the CLE on this and making it possible to make this free. I forgot to say my name. That seems kind of relevant. My name is Vern Ball, and I'm a deputy county counsel with Sonoma County. I have extremely esteemed panelists here that I'm very excited to have today. I'm going to let you read this slide yourself and tell you a couple of things. One, Nicole Granquist is an amazing attorney who I first met when she was on the other side of the table. It was a very difficult table. We got through it. I ended up having a lot of respect for her. I think that she's a very smart and one of the best attorneys in this space. Tamron is amazing. I would commend anybody here interested in stormwater to read her recent article for the California Environmental Law Section's Law News, I believe it is. It's a journal. You can ask me for it, and I might be able to give it to you if you're not a member. And she has a lot of regulatory experience and is a great interlocutor. I really respect getting her excellent opinions on this. And Esty Coos is with the city attorney's office in San Francisco. I should say city, and you're an honorary county counsel.
There we go.
One of the few city attorney and county counsel overlaps in the state. And I will say that she is part of the team who brought us the outcome in the Supreme Court, kind of a powerhouse team that San Francisco is lucky to have, and we're lucky to have her today. Without further ado, we're going to get into our brief background. And Tamron is going to start, and then Nicole is going to fill in some of the background as well.
Sure, thanks, Fern. So this is, I think, the most brief of primers that we can do. And it's just to illustrate sort of the backdrop of the San Francisco case. So we have the Federal Clean Water Act, which governs NPDES permits. We're very generally talking about a discharge, and of course, all of these terms are defined and worth fighting over. A discharge of a pollutant from a point source into a water of the United States. And if you have one of those things, you must have an NPDES permit. In California, we have the water code. Porter and Cologne were the two legislators who came up with this section of it. And we have waste discharge requirements that are issued under California state law. Those govern a discharge of a waste that could affect the quality of waters of the state. And if you have one of those, you must have a waste discharge permit. So key distinctions to note, water is different under federal law versus state law. Federal law, you're going to want to look at the Sackett opinion. Under state law, you're going to be talking about a much broader set of waters, including groundwater. The other key distinction I think worth mentioning is Federal Clean Water Act talks about a point source. And Porter Cologne does not. You're talking about point sources, non-point sources, anything that's potentially affecting the quality of the waters of the state.
Hi, everyone. So the just to give a little bit more backdrop before we dive into the nitty-gritty of the case, for those of you who may not be practitioners in this arena, just understanding that, as Tamron explained, there's Clean Water Act, NPDES permits, there's Porter Cologne waste discharge requirements, and where you are discharging into a waters of the United States, those are also defined as waters of the state. And so it's important as we get to topics that we're going to talk about later on in the talk, of distinctions of state law, getting into NPDES permits and what that all might mean. Understand that in the state of California, when an NPDES permit is issued, it is also issued as a waste discharge requirement. So it is an NPDES permit and a waste discharge requirement. That will matter later to understand that. So NPDES permits and WDRs, these combined, take requirements from both federal, can take requirements from both federal and state law. One of the key distinctions currently between the Federal Clean Water Act and Porter Cologne is that NPDES permits are enforceable by third parties in federal court under the Clean Water Act. State law only WDRs, when you're just discharging to waters of the state, they are not subject to third party citizen suits, and that will play into some of the discussion that we talk about later. But when those are combined, when state law and federal law in NPDES/WDRs are combined, those can all be potentially enforceable all in federal court in a third party citizen suit. So wanted to give that backdrop so some of the issues that we talk about later make sense. So I think with that, we've acronymed everybody to death and we can jump into the city and county of San Francisco.
Hi everyone, I'm Esty, and now that we have a shared understanding of how discharges are regulated, I'll walk you through the San Francisco versus EPA case. So this case involves the question of whether the EPA and authorized states can include what we're calling end result provisions in discharge permits. And end result provisions are permit terms that make the permit holder responsible for the quality of the water in a receiving water body rather than the quality of the permit holder's discharge into the receiving water body. So in our case, San Francisco would be responsible for the quality of the Pacific Ocean versus the quality of the flows coming out of its outfalls. So San Francisco challenged the end result provisions in the permit authorizing discharges for the stormwater and wastewater collection and treatment system on the western portion of the city, known as the Oceanside system. And today I'll provide detail about San Francisco's combined system and our permit. But it is important to know that the end result provisions are ubiquitous in discharge permits in California and across the country. And so if your client has a discharge permit, then in all likelihood, it contains very similar end result provisions to the ones in San Francisco's Oceanside permit that's at issue in this case. And in the next couple of minutes, I'll explain more about San Francisco's system, show you the challenged permit terms, explain our path to the Supreme Court, summarize the decision, and share about some of the post-decision developments. San Francisco has a combined sewer and stormwater system, and this image is a cross section of a combined system. So unlike other municipalities that maintain separate sewer and stormwater systems, San Francisco treats both wastewater and stormwater before discharge, which is an overall benefit to water quality. And the system handles most rainstorms by sending the combined sewage and stormwater to the treatment plants for treatment and disinfection prior to releasing it to the bay or ocean through deep water outfalls. So you see that there, just to walk you through this image a little bit more. Um, Obviously, with gravity, the water will flow to the lowest portion there. And if you're looking at the transport box in the middle, normally when the flows are low, either just not on a rainy day or a smaller regular sized storm, the flows would raise up to the lower pipe there and then flow either through gravity or a pump station to the treatment plant and then be discharged through the deep water outfall. But in big storms, you can see that the water would rise up and then go out through the discharge structure there into a more of a near shore water body. And for those with eagle eyes, take a nice look at the discharge structure. So as I said, some extreme storms can exceed the capacity of the system, requiring partially treated discharges through permitted nearshore outfalls along the bay or ocean. And those discharges are known as combined sewer discharges. Those discharges are authorized by our EPA and regional water board permits. And when discharges do occur, they consist overwhelmingly of stormwater. Pictured here is one of San Francisco's outfall structures on Ocean Beach. Note the graffiti. San Francisco supports the arts. And if you're paying attention to the prior slide, our consultants who made the graphic also support the arts because they included the graffiti on the discharge structure, which I got a kick out of. San Francisco's extensive system of underground storage tank, transport and treatment boxes minimizes the frequency and volume of these discharges. You can see the transport storage boxes in this image. They're the red items. It's kind of like an underground moat that the city built to minimize discharges. They're huge boxes, um, many feet tall, that that the stormwater can uh, be stored in, so that we minimize the amount of discharges that go out. So this image also depicts that the city effectively has two combined sewer systems, one serving the western portion of the city known as the Oceanside system, and another serving the eastern portion of the city known as the Bayside system. The Oceanside and Bayside systems each have their own discharge permits that authorize the discharges of the treated effluent and the combined sewer discharges into the ocean and bay, respectively. And those permits are combined NPDES and WDR, just to make sure your acronyms are still jingling around in there. Okay, so San Francisco challenged two discrete provisions in its Oceanside permit, and they are excerpted here on the screen. These are just, as you can see, it's just two sentences within what was a 150-page discharge permit. These are what were ultimately called by the court end result provisions because the focus is on the water body, not the discharge. So you see it's highlighted, discharge shall not cause or contribute to a violation of any applicable water quality standards, and neither the treatment nor the discharge of pollutants shall create pollution, contamination, or nuisance as defined in the water code. San Francisco brought a challenge against both EPA and the Regional Water Board since those regulators jointly issue San Francisco's Oceanside permit. However, most of the action in this case happened in the federal challenge against EPA. Despite media reports to the contrary and corresponding concern by the public and even San Francisco's own Board of Supervisors, the city did not challenge the Clean Water Act or any EPA regulation or rule, or the extent of EPA's jurisdiction over water quality. San Francisco challenged these specific provisions because what they mean in practice is that the city can be held liable for contamination in the Pacific Ocean that others, not the city, have caused or are causing. And that creates an obligation that was impossible for the city to comply with. Also, end result prohibitions don't tell the city in advance what standard it needs to meet to protect water quality. And San Francisco would only find out after the fact when it faced an enforcement action. EPA relied on 33 USC 1311 B1C to justify the end result provisions, and this portion of the United States Code is, the title of it is called effluent limitations. And EPA's position was that the reference in Part C to any more stringent limitation allows regulators to impose any kind of permit term that they think is necessary to protect the water quality. It's a very broad interpretation, whereas San Francisco had two positions. One was that the reference to limitation here in Part C means effluent limitation, which demands that a restriction be on the quality of the effluent. And our alternative argument was that at a minimum, it can't mean to a demand to avoid violating water quality standards because that's circular and doesn't implement the water quality standards. Challenging the end result provisions has been a very long journey. Here's a timeline showing some of the major events along the way. In 2019, San Francisco objected to the inclusion of end result provisions in its Oceanside permit, but they were included in the permit anyways. So in 2020, San Francisco filed an administrative appeal with the Environmental Appeals Board. The board denied our appeal. That's a special tribunal just for cases with EPA jurisdiction. And that outcome was expected since the board typically upholds whatever action EPA has taken. In 2021, San Francisco sought review by the Ninth Circuit Court of Appeals. In 2022, after an unsuccessful mediation attempt, the court heard oral arguments. In 2023, the Ninth Circuit issued a divided opinion denying our petition and narrowly ruling in EPA's favor. The dissenting opinion supported San Francisco's position and found that end result provisions were invalid because they're inconsistent with the text of the Clean Water Act. And Judge Collins explained by imposing those provisions, EPA fundamentally abdicated the regulatory task assigned to it under the Clean Water Act, which is to issue permits specifying what a permit holder must do to ensure its discharges do not impair water quality. The Ninth Circuit opinion left San Francisco with an unenviable choice of either accepting the end result provisions and exposing the city and its ratepayers to potential enforcement for unspecified, unknown, and unknowable receiving water quality at a huge potential cost, or appealing the decision. We evaluated numerous factors in considering whether to seek review by the Supreme Court, including politics, costs, practical implications, including what it would mean if we lost. We knew that if we pursued the case, we would have strong support from clean water agencies and municipalities across the state and the nation who face the same challenges with similar provisions in their permits. Ultimately, for San Francisco, this case would ask the court to ensure that EPA follows the Clean Water Act and gives permit holders clear standards that actually prevent water pollution before it happens. And a favorable outcome would protect the environment and put the city in a position to protect its ratepayers. So ultimately, that was an outcome worth fighting for, and we appealed to the Supreme Court. We knew that the likelihood of obtaining Supreme Court review is extremely low. Only 1% of cases that seek review are granted the opportunity to be heard. Importantly, the Ninth Circuit opinion in the case created a split with the Second Circuit, with the case called NRDC, Natural Resources Defense Council versus EPA from 2015. In that case, it was actually the environmental organizations led by Natural Resources Defense Council that brought a lawsuit against EPA challenging discharge permit conditions similar to the end result provisions. The Second Circuit unanimously found that such provisions are impermissible because they add nothing to instruct permit holders on how to prevent pollution, instead only imposing liability after water quality violations have already occurred and quote, "The point of a permit is to prevent discharges that violate water quality standards before they happen." Uh, Numerous amicus curiae friends of the court brief were filed in support of the city's position. The city was joined by more than 60 amici, including the 400 cities represented by the California League of Cities, the 2,800 members of the National League of Cities, over 2,300 members of the National Association of Counties, the California Association of Sanitation Agencies, and the National Association of Clean Water Agencies. The breadth of support demonstrated that public water agencies across the nation grapple with similar provisions in their discharge permits and understand, how important this issue is. San Francisco also got significant support from unsolicited groups, including trade groups like the National Mining Association, the American Farm Bureau Federation, and fuel manufacturers, among others. This resulted in headlines about liberal San Francisco and its, quote, "strange bedfellows." So maybe got the case a little more attention than we might have otherwise had. We believe this circuit split and the broad amicus support are what caused the court to hear our case. In October 2024, the Supreme Court heard oral argument, and my colleague in my office, Tara Steele, argued the case on behalf of San Francisco. She is not a environmental practitioner. She is an appellate specialist. So if you can imagine having to wrap your head around the entire Clean Water Act and every aspect of our um, treatment process, it was quite a task. Helping her prepare for oral argument and attending the proceeding was a career milestone I never expected to have. And this picture is of San Francisco's legal team on the steps of the Supreme Court, taken immediately following the oral argument last October. In an interesting twist, in May 2024, while the parties were briefing the case for the Supreme Court, EPA, the Regional Water Board, and Baykeeper, a nonprofit environmental group, sued San Francisco in federal district court to enforce the end result provisions. San Francisco was able to use this development in our briefing to explain to the court that the threat of enforcement that we had flagged in our briefing was no longer theoretical, it was real. To put a finer point on that, San Francisco estimated it would cost San Francisco's ratepayers well over $10 billion for projects to meet plaintiffs' demands just on the Bayside alone. So that would result in an annual average sewer bill of nearly $9,000 per household. And it would also compound the city's cost of living crisis and force more than 8,000 San Franciscans into poverty, all for the possibility that San Francisco met this unspecified target and still wouldn't find out till after the fact. On March 4th, 2025, the Supreme Court issued its opinion, ruling in San Francisco's favor in a split 5-4 decision. Justice Alito wrote for the majority. The court held that end result provisions are at odds with the text, structure, and history of the Clean Water Act. Justice Barrett wrote a dissent joined by Kagan, Sotomayor, and Jackson. When we attended the oral argument, we could sense that there would be a split, but we didn't predict that it would wind up being boys versus girls. The decision does a good job describing what was and wasn't at issue. The press coverage about this case did a bad job of making this about narrative requirements. Narrative requirements are non-numeric requirements that typically impose best management practices, like operations and maintenance requirements. That the court explained and explicitly stated that this case is not about narrative requirements. They were correct. San Francisco did not have any issue with narrative versus numeric. And the opinion coins the term end result provision, a permit term that makes permittees responsible for the overall water quality. I noted earlier that our first argument was that the reference to limitation in 1311B1C was a reference to effluent limitation. That that was more of a unanimous loser for us. The court rejected that argument 8-1. Next slide. But our second argument prevailed, and the court pointed to the meaning of a limitation and to the verb implement to reject the end result provisions. You know, a limitation has to mean something. That has to restrict something, and implement means, you know, you have to effectuate something. So in our view, the decision upholds the Clean Water Act's critical role in protecting water quality and simply requires EPA to fulfill its obligations under the Clean Water Act as intended by Congress. And the ruling makes clear that permit holders like San Francisco are responsible for what they discharge, and the EPA has the tools at its disposal to ensure that dischargers' water quality is protecting the water quality standards. So, but permits should not be written to punish permit holders for things outside of their control, such as the overall water quality of a shared water body, where many other factors affect water quality. Sort of an interesting bit of the history. Before the Clean Water Act was the Federal Pollution Control Act, and that was a structure that was sort of similar to the end result provisions and required compliance in the overall water body as opposed to your discharges. And Folks may recall part of what inspired change in the regulatory approach was the Cuyahoga River caught on fire in the summer of 1969. And that event helped spur an environmental movement that helped shift the regulatory structure from one where parties were responsible for violating water quality standards, which was generally considered to be an unsuccessful approach, sort of epitomized by this river on fire, to one where permit holders were responsible for their discharges. And the Supreme Court emphasized that its decision is consistent with Congress's intent in switching regulatory frameworks. Drake says no to making permittees responsible for the overall water quality, and yes to making the regulators write permits that impose specific requirements to ensure water quality standards are met. So what happened after the case came down in March of this year? Just 1 month after the SCOTUS decision, EPA and the Regional Water Board filed an amended enforcement complaint against San Francisco, omitting the claims based on the end result provisions. And what's interesting about that is even was that the permit at issue in the complaint was the Bayside permit, not the Oceanside permit that was at issue in the SCOTUS case. And we'll discuss how this compares to approaches for other permit holders with end result provisions in the next portion of our discussion. After the SCOTUS decision, the case was remanded back to the Ninth Circuit. We anticipated a whole new round of briefing with the parties arguing what the implications of the decision would be. But instead, the Ninth Circuit unilaterally vacated the challenged permit terms, which was an ideal result for San Francisco. And in the parallel state court case against the Regional Water Board, which had been stayed during the pendency of the federal appeal, the parties reached a stipulation that the Ninth Circuit's vacatur of the permit conditions, plus the expiration of the Oceanside permit, which was administratively continued to, just as a reminder of how long how long this path has been, rendered San Francisco's action moot, and the parties further stipulated that the challenged permit terms were not enforceable, which will also have tie-ins to our discussion later today. And with that, you now have the foundation you need for the next portion of our discussion about the implications of the decision.
Sure. And also, as a matter of housekeeping, it's probably worth saying I am formerly an attorney with the Water Board Office of Chief Counsel, and I did represent the San Francisco Bay region during the issuance of the 2013 permit to the Bay side, and also participated in settlement negotiations, which of course we will not be discussing today, that had to do with EPA's enforcement. Um, I guess I kind of want to back up a little bit to give a little more background on. We talked about Porter Cologne, we talked about the Clean Water Act, and San Francisco is in this very interesting position of having a combined sewer, which in California there are only two. So, yes, nationwide there are about 700 systems. And of course, if you go across the pond in Europe, there's 700,000 systems that are combined sewers. So, while this is a very interesting issue, I think my refrain for today will probably go along the lines of this is a very limited issue. Um, what's interesting here is the type of permit terms that you see that govern San Francisco are unique. So we're going to talk about these issues about causing and contributing. We're going to talk about these end result provisions, but I think it bears mentioning that San Francisco, their permit is very distinct from every other permit in the state of California, with the possible exception of Sacramento, where the other combined sewer is. So I think that's kind of one of the background issues. Oh, and I should also mention that I am not representing the Office of Chief Counsel today. These are all my opinions. Um, I did not consult with them in discussing what is going to be said today. So yes, ordinary NPDES permits for wastewater treatment plants, they have effluent limitations. Those are technology based. In other words, what is the capacity of technology to treat the thing that we want to treat? And that's relevant, of course, when you have constituents of emerging concern like PFAS or microplastics or discharges of things like birth control pills into your water. How do you treat that, right? What's the technology? And the other one is water quality based. In other words, what do we need to do at the wastewater treatment plant in order to protect the water quality? Receiving water limitations are the types of things that we were talking about today, and Esty gave a really nice background of those. How do you protect the receiving water? Is it that you protect what's coming out of the pipe, or is it that you say you cannot alter the receiving water? And that's the focus of the Supreme Court's order. There's additionally operational maintenance requirements, monitoring requirements, and usually NPDES permits for wastewater treatment plants are issued only by the regional water boards unless they have a deep water outfall like San Francisco did that extended, I think it's 3 miles offshore. Combined sewer permits, this is a different beast entirely. So the CSO policy, combined sewer overflow policy, was established. The Congress established this in 1994. It's an excellent read. I mean, just certainly in terms of wow, this is a whole different beast that we were talking about. So again, there's 9 minimum controls, which is similar to this technology-based requirement that you would see in a normal permit. What can you do? What does the technology allow you to do? And then the second set of requirements is this long-term control plan. And the backdrop of this one is that at the time that we were in discussions with San Francisco and EPA came on board, the long-term control plan was sort of this series of documents, but was not one compiled document. And many of those documents, if not most, were dated in the 1990s. So here we are in the 2000s saying, you really ought to have a plan, right? So again, this is again a completely different animal than what you would see at a normal wastewater treatment plant system. The long-term control plan is intended to basically take stock of what does your system look like? What are you doing to implement those 9 minimum controls? How are you getting to water quality standards? How are you ensuring that your discharge is consistent with water quality standards? That's the objective. So there's a lot of what have you done for me lately type of questions that go into those sort of analyses. So going back to the permits for San Francisco, these combined sewer permits, similar receiving water limitations, similar operation and maintenance requirements, similar monitoring requirements. And as Esty pointed out, these are jointly issued by US EPA and the Water Board. And I think there's one more slide that gave an important distinction that was worth mentioning. There we are. So if you look at a lot of the San Francisco Bay permits, the language that we were talking about earlier, let's go to the right side of the screen. The language at issue in the San Francisco case was the discharge shall not cause or contribute to a violation of any applicable water quality standard. And if you look at most of the permits that San Francisco issues, they talk about the discharge shall not cause a violation of any water quality standards. So one of the key issues that San Francisco had concerns with is, well, if we're discharging and there's 8 other people discharging, how do you know that we're the one that caused the violation of the water quality standard? And or more particularly, if we contributed one molecule, how do you know that puts us on the hook unfairly? And so I think that is not typically an issue under ordinary NPDES permits. That causal standard, the water board, were they to enforce this receiving water limitation, which I will note in my 12 years with the water board, I never saw that enforced outside of what we're talking about today. So I think that raises questions about, is this a regulatory issue or is this a Clean Water Act issue, which we're going to get into later, but I'll flag that issue. But you can see the distinction in the language, I think is important to notice. And one other point that didn't make this slide was it's in the Code of Federal Regulations. Let me find the citation for you. I think it's 122.26. And also talking about, it's that same language, the cause or contributes. So, so I don't think EPA was making this up out of whole cloth, but I think the San Francisco permits are sort of recognizing the contribute language. You know, could that be one molecule, or do we need to have a causal connection? So interesting to look at the 2 different types of permit, the language in the 2 different types of permits.
I appreciate that perspective. I sort of along the lines of what you were just saying about the language being in the Code of Federal Regulations. Um, that's um, that's my perspective as well. Is that this language does have a source in the Code of Federal Regulations, and if you look at the permits, they'll in your fact sheet, it usually will say what the basis for the language is. And so, in my opinion, this distinction is not a result of San Francisco having a combined sewer system. Instead, this is simply inconsistent drafting by the water board. And as a case in point, San Francisco's Bayside permit says the discharge shall not cause a violation of any water quality standards for receiving water. It does not say cause or contribute. And an important element here is the basis. And if you look in San Francisco's permits, they tend to point to 40 CFR 122.44 D1I, and that has that similar language that you were talking about. It says, to summarize it, limitations must control all pollutants which may cause, have the reasonable potential to cause, or contribute to an excursion above any water quality standard. So, while I think you're correct that the typical language that the water board uses does not say cause or contribute, if they relied on that same authority, they could be saying that in anybody's permit.
Thanks. So one thing that is the most interesting aspect of the post-regulatory world after this case is, of course, all of the 9 water boards and the state water board deciding how they're going to handle implementation given the wide array of types of discharges that are regulated, whether that's process water, stormwater, or otherwise. And so the what we're going to talk about here is focused on the wastewater side of the coin. We'll get to stormwater in a minute. So when we talk about either an industrial process water or a municipal wastewater stream, the state has issued guidance as to how to handle what do the water boards do with the receiving water limitations provisions that exist in the NPDES permit for these agencies. And the implementation guidance, there's obviously a lot more detail. We encourage folks who are interested or working in this field to grab that implementation guidance off of from the State Water Board. But we've distilled the steps that they describe, of course, with more particularity here, so that folks can see that the water boards are taking the steps in the wastewater context to remove receiving water limitations in NPDES permits for those types of discharges. And this is the recommendation here, these 4 to 5 steps to the water boards about how they go about doing that. I think the key that is anytime you have evolution of thought, evolution of regulatory environments, there's always unintended or perhaps maybe intended consequences. So we have receiving water limitations that may be removed from these permits, but that's not the end of the inquiry. As you can see in terms of step 2 and step 3 here, the first sort of set of questions to the regulators once they remove those receiving water limitations are, can existing receiving water limitations be reframed as an effluent limitation, or are the remaining requirements protective of water quality standards? And if not, then the water boards are encouraged within the context of the federal and state law that authorize NPDES permit requirements to impose additional effluent limitations or other discharge prohibitions that would be consistent with basin planning, federal law, and state law. So one of the sort of consequences of this decision that is to be determined, because we are so early in the process, is how many circumstances will there be where there will be receiving water limitations that are removed and no new limitations are imposed, or are there going to be a number of permits where receiving water limitations are removed and there will be new discharge limitations. We have one sort of tranche of permits that were adopted by the Central Valley Water Board for wastewater treatment plants some months ago, and they removed the receiving water limitations. And because of the very robust data sets that wastewater treatment plants have and the reasonable potential analysis, that is, for those not familiar, that's the process by which data, discharge data, receiving water data gets viewed to see, do I have a reasonable potential to exceed a water quality standard? And if so, do I need an effluent limitation? Because of the robust data sets at wastewater treatment plants and the reasonable potential analysis that the water boards go through when they set NPDES permits for treatment plants, the answer was we don't need new effluent limitations for that first sort of tranche of permits that we saw post Supreme Court decision. So those are examples where no new limits were required. I'm also involved in a couple permits, one that is proposed, not yet adopted at the San Francisco region, where it's an industrial discharger. So again, back to process water, not municipal or industrial stormwater, but the permit was being renewed in the matter of course of the normal expiration and renewal process, and the receiving water limitations are being removed. But there was a new effluent limitation that is now proposed for dissolved oxygen, and that was based on sort of technology-based requirements and best professional judgment by the water board staff, that because of this industrial discharger treatment system, which in order to reduce selenium at a very expedited pace, they have to depress the dissolved oxygen within the system to very low, and then they raise it back up. And so the water board has elected to impose a new effluent limitation for dissolved oxygen that didn't exist before, and basing it on that treatment technology and best professional judgment to say, now that we don't have a receiving water limitation for DO, we're going to now impose an effluent limitation. So we're seeing a variety of outcomes there, and it is going to be largely based on, the sort of the robustness of your data set, and also different aspects of your activity that may or may not result in additional effluent limitations being imposed. So this is something that we're all watching into the future as all of a number of NPDES permits are being re-upped and reconsidered and reissued over the next coming number of months and years, and we'll be keeping a watchful eye. The other item that this implementation guidance provides is optional language to the water boards if they want to preserve the nuisance provisions that were imposed under state law in the city and county of San Francisco permit. That's the prohibition on a discharge creating a condition of pollution or nuisance or contamination. Those terms are defined in state law 13050 of the water code. And the guidance provides different options for water board staff to either remove or reinsert under state law some of those provisions. So we didn't have time to go through all of those options in detail today because we have so much to talk about, but I highly encourage folks who are working in this field to read that implementation guidance and to understand the options that the water boards have set forth for themselves, and make sure that folks review their data and their facilities to determine, what the best approach is there and be prepared to speak with the water boards about that.
And we're gonna talk to Tamarin and then to Nicole about really what this means for Porter Cologne. I'll just note briefly, the way that Esty discussed this case, it sounded a lot like good permitting, right? You don't impose requirements that you don't really know what they are, and you provide notice. I'm not sure that Tamarin has the same perspective on that, but it's not up to me. And it's not up to Tamarin. We have some Article 3 people and some state regulators and federal regulators. So Tamarin, what does this mean for Porter Cologne?
So I'm going to object to the question, Vern. So I can talk a little bit about my predictions for the future in terms of permitting, but I don't think anything is going to change with Porter Cologne. So if you'll allow me to modify your question. And I want to also back up to my perception of permitting, which, having advised on probably 100 NPDES permits, I mean, many, many NPDES permits, we do want permits that are enforceable. We do want clear provisions. One thing that's sort of interesting to think about is, I mentioned earlier, contaminants of emerging concern. How do you have a backstop for your contaminants of emerging concern? How do you make sure that if something gets by the wastewater treatment plant, because we don't even know it exists, but we see an impact in the receiving water, how do you hold the wastewater treatment plant accountable? So this was definitely discussed at the Supreme Court in the transcript. The transcript is definitely another document. We're giving you lots of things to read for bedtime. I would add that to the pile. But so that's sort of the kind of backdrop of what are we doing with these receiving water limits. In terms of what happens going forward, I mean, my perception is that if you take away the receiving water limits, it's going to put more emphasis on effluent limits, which, if that's what folks want, great. But oftentimes people don't want to be told, here's this effluent limit and you have to meet it. They would actually rather do the discharge, and then if something bad happens, respond to it. So it's sort of interesting. The argument that San Francisco is making, I think, is actually contrary to a number of folks out in the field who have permits to discharge, because it will put increased pressure on developing effluent limitations. And the way you do that is through monitoring. So I would definitely, if I'm looking at my crystal ball, and my tea leaves, I would expect to see permits that are going to require more monitoring, which, again, folks don't like to do more monitoring. It's expensive. Sometimes it gets you great new information. A lot of times it doesn't. It depends on what you're looking for. It depends on how often you have to look. So those, I think, are sort of my predictions in terms of going forward, what I would expect to see for permits.
Yes. So remember when we talked in the beginning of our webinar about NPDES permits also being WDRs, and that when they are issued to satisfy both federal and state statutory discharge requirements. And we said more on this later when you have state law requirements going into a federal NPDES permit, and why does all of this matter? And here we are. Just by way of background, the receiving water limitations provision has been largely enforced, and I think a lot of the concern has been in the past in the citizen suit arena. We could have a whole 2-hour talk on receiving water limitations and citizen suits, but given the time frame, I'll sort of give just a very quick primer. So the receiving water limitations in the stormwater context has been litigated and been, I think, a struggle for especially for the industrial and municipal stormwater agencies, because of the difficulty of being able to pinpoint compliance, especially for industrial dischargers who may discharge into a municipal system as opposed to a nearby river, creek, or stream. And it's really difficult to fully assess impacts to waters. And so you're relying just on your discharge data. And discharge data really shouldn't be strictly compared to receiving water quality standards and compliance assessed that way. But that is how the outcome of a lot of citizen suits have occurred. And it presents a problem for a lot of the stormwater permittees to have these receiving water limitations be so general and nebulous in their requirements. And so I think admittedly, a lot of folks were watching this case because of the citizen suit vulnerability and liability of receiving water limitations. Quite frankly, a little less so from a water board enforcement standpoint. Obviously, City and County in San Francisco had its own more significant regulatory compliance concerns and costs. But usually it's citizen suits where when we start talking about receiving water limitations, it's the area that gets sort of the most attention. So keep in the back of your mind that when we talk about the receiving water limitations and the decision of City and County San Francisco saying this isn't appropriate under the Federal Clean Water Act, folks would say, great, these are out of my NPDES permit. But just like Tamara just referenced, that Porter Cologne continues to be state authority. The water boards have asserted that they think that they do have authority under Porter Cologne to impose those requirements, to continue to impose those requirements on dischargers. The question becomes, well, how, where, and what does it matter? And if citizen suits are sort of one of the larger concerns, then the idea that you have an NPDES permit and the water board says, okay, great, this may not be a provision that is implementable under the Clean Water Act, but we believe we have authority under Porter Cologne. So when we do that combined NPDES permit WDR requirement, we're going to put that receiving water limitation back in the permit, but we're going to say it's a state law only provision. And in that circumstance, I think, the water board is, acting in a way that it feels appropriate to say, we understand it's not federal, but this is our interpretation of our state law, and we're going to put in big, bold letters, state law only. So one of the concerns from the discharger community in that circumstance is that there has been a case law throughout the nation about whether or not, when a state law only provision is placed within the four corners of a NPDES permit, whether or not that transmutes that state law only provision back into being federally enforceable in an NPDES permit in federal court under the Clean Water Act, such that it's sort of just back where you started. And there was a case that the Ninth Circuit had recently decided. There had been earlier cases talking about this within our circuit, mostly at the district court level, but some cases in LA. But the Puget Soundkeeper Alliance versus Port of Tacoma case had brought this issue to the forefront at the Ninth Circuit to say, is this enforceable? Because they had that exact scenario of an NPDES permit, which had very clearly identified state law only provisions included to satisfy their state law. And the Ninth Circuit opined that third parties can sue in federal court to enforce state law only conditions if even if they go beyond the scope of the Federal Clean Water Act, if you place them in an NPDES permit. So I think the case was filed and appealed to the U.S. Supreme Court. I think folks were assuming with the decision of the city and county San Francisco case that the logical sort of 1-2 punch of analysis would be receiving water limitations are not federally enforceable. And by the way, if states want to impose those requirements to do it under state law, that the Supreme Court would then follow on and say, and those aren't enforceable in federal court, or else it sort of could vitiate the city and county San Francisco case. And the court denied cert in June of 2025. So the Ninth Circuit case stands. And so this becomes, I think, when we're talking about working with our water boards on permitting and working through these very thorny issues of where is this requirement coming from? Where does it belong? Are we transmuting its enforceability into a different thing? That this case sort of is a hurdle for folks accepting receiving water limitations as a state law only requirement in their NPDES permits. So we now have a continued split in authority. The Second Circuit found the opposite. They said, no, you cannot be sued in federal court via citizen suit for violations of state law provisions, including in NPDES permits that exceed the Clean Water Act's requirements. And now the Ninth Circuit has contradicted that, and the U.S. Supreme Court did not elect to resolve that split in authority. So I think from some of the permitting implications are working, when the water board says, well, we think we have authority under Porter Cologne, and we're going to put that in as a WDR, the question becomes, how significant is that to your organization? And do you need to ask them to place those things in separate waste discharge requirements under Porter Cologne, provided everyone agrees that they have authority, which I won't argue here, but let's just say for the sake of argument, they did, then folks might be asking for separate waste discharge requirements, which is technically fine, although of course it will increase workload of the state. And so I think, we'll see how that issue is played out again over the next few years is going to be a significant permitting issue for folks for fear that the city and county of San Francisco case will be diluted because of state law requirements that make it into NPDES permits.
I'll just comment that it sounds like a car crash. Like the Supreme Court says, you shall not require this, you can't require this. And then there's this mechanism to require it where you end with an end result, pardon the pun, that it's a federal requirement because it's a state requirement that's not a federal requirement, but required by virtue of federal law. I think this is going to be interesting to see how it plays out.
Very interesting.
Okay, so here comes some juicy content. What comes next for stormwater? I think Tamron will be going over initially what the discussions have been with the regional board, and then Nicole is going to be filling in some other information.
State of California has certainly taken the position in briefs that the San Francisco case is limited on its facts, that it's not going to deal with stormwater. That was from the Sunnyvale amicus brief. So, and again, I think the point I made earlier, this idea that a combined system is it's just different. It's a different beast. It has different types of requirements. And I'm going to invite Nicole to jump in because I think she created this slide.
Sure thing, no problem. I didn't know if you wanted to talk about the 402 P3B issue sort of separate from 301. I'm happy to fill in. So when we talked about the state guidance, when we were talking about those process water and the wastewater treatment plant and the guidance where we had the slide a few slides back on the state's guidance on how are we handling permitting going forward for things like wastewater treatment plants, or maybe an industrial process water discharge. The guidance with the 5 steps that we went through earlier, that's where you turn. Now you move into the very complicated subject of municipal stormwater, which could have its own day-long webinar about all of the issues involved there. But the key to understand as to where things appear to be headed currently is all we call the municipal separate stormwater systems. So those are municipal systems that collect all of the stormwater that falls in a city, county, etc. We call those MS4 systems for those who may not be aware of that acronym. So those municipal systems, or MS4s, are all regulated by specialized MS4 permits that are issued by the state. Those permits largely have been best management practice and program based, not numeric water quality based effluent limitations, except there are some exceptions to that where particular TMDLs have numeric water wasteload allocations that get pulled in. But for the most part, we'll just say, for the most part, municipal stormwater has had less direct effluent limitations to meet for obvious reasons. You have these very large jurisdictions. Sometimes you may have 3,000, sort of discharge points to receiving waters in a municipality, not akin to a collection system, a sewer agency where everything is collected to one point at a treatment plant and a discharge. So what those permits have been based on is programmatic requirements of which is why you see the MS4 permits can be very long in their description of various programs that the municipality has to implement in an effort to control pollutants. And then all of those permits have receiving water limitations. And many of those permits have receiving water limitations that say don't cause and contribute, depending upon the age of the permit. And then the permit will say the way that you comply with this receiving water limitation is to do all of these programmatic items. There's been a lot of litigation about whether or not all those programs provide legal defense on the receiving water limitation enforcement, and we won't get into that too much here, but just understand those MS4 permits are generally program, receiving water limitations, monitoring, etc. So the state has taken the position that the city and county of San Francisco case, which when you parse through that decision, it is a decision that is largely based on Clean Water Act Section 301, which is 33 USC 1311. Why we all decided to rename all the numbers of statutes with the Clean Water Act, I'll never know. But it's 301 is sort of the source of the court's decision and the parsing of what's a limitation, what's it mean to meet and implement, and all of those things. So when you read that decision, the state has taken the position that with municipal stormwater, which is further regulated in Section 402 of the Clean Water Act, 402P was the provision in 1987 that when the Clean Water Act was amended to specifically regulate stormwater, was an additional statutory provision that then specified what Congress wanted folks to comply with when it came to municipal and industrial stormwater. Industrial stormwater harkens back to 301 and says meet water quality standards. 402P3 says for municipal stormwater, meet maximum extent practicable pollution control, because at the time everyone knew that folks were not going to build treatment plants for stormwater. So it was more of a management practice programmatic approach. So the state has issued guidance, and there's a lot in this guidance. Obviously, for purposes of this discussion, we're sort of hitting the highlights, but I highly recommend you read that. It's 5-6 page guidance document about why the state feels as though receiving water limitations should be retained in NPDES permits for MS4 systems. And the argument that they are asserting is that the city and county of San Francisco case was based on the terms of 301 and municipal stormwater is based on 402p3 MEP. I think that this will probably be the subject of future litigation. I think there are some that believe you don't get to 402p3 until you can't jump there without going through 301 first. So I think, some believe that that's a parsing of the statute that is too narrow. And the argument from the state is we've been told something more specific for municipal stormwater. We think those receiving water limitations escape the Supreme Court's analysis under 301, and because of the MEP standard that doesn't have the same words as 301B1C in the court's decision, that they can sort of distance themselves and say, this is very separate. We're going to retain receiving water limitations in stormwater permits, and to essentially keep the status quo. Again, like I said, folks are going to have varying degrees of agreement or disagreement with the state's interpretation on that point. But for now, the state is not planning on making any changes to MS4 permits. Now you've got industrial stormwater that is not subject to the MEP standard. It is specifically references back to water quality standards in 301 B1C. And so the next frontier, and the state has specifically said they have not yet decided what they're going to do with other permits from the State Water Board, like the general industrial stormwater permit, the general construction stormwater permit, those that might not fall under the municipal stormwater permitting provisions of the Act in 402P. And they have not yet enunciated what their plans are with respect to receiving water limitations for those discharges, and whether or not they're going to be amending those general permits. We are still awaiting the state's position on that and guidance. And I don't know, Tamron, if you have any insight as to any timing of what we might expect, or if it is still very much in the we haven't made up our mind stage. But we're seeing as sort of a split in stormwater, probably a split in stormwater management between MS4s that are following 402 P3B and the industrial storm and construction stormwater permits that are more specifically linked to 301.
Right. So I'm not sure if you're referencing the LA permit. It's the commercial
No.
industrial. Okay, because I think again that's sort of a different circumstance
Yeah.
where
Yeah.
you have a very highly industrialized area as opposed to MS4s, which are generally a mix.
Yeah.
But no, I haven't heard anything on specific timing.
Yeah. No, this would be more on the IGP, the industrial stormwater general permit, which, regulates what, I don't know, these 15, 20,000 facilities throughout California who are they are engaged in the 11 categories of industrial activities that end up requiring coverage under the State Water Board's industrial general permit, which also has receiving water limitations. And quite frankly, that's the permit that is the most frequent circumstance that we see citizen suits using receiving water limitations in order to assert claims. And so the industrial stormwater folks are sort of waiting with bated breath to see what the state is going to do or not do with respect to that permit, and whether or not there needs to be more affirmative action by the folks who are subject to that permit to force an outcome where receiving water limitations may be limited or removed. But that will also bring about, like we talked about in the individual permitting context of wastewater treatment plants or industrial process water, is whether or not the removal of those receiving water limitations, how the state would deal with any additional discharge limitations. That permit is sort of unique because it already has numeric action levels that aren't effluent limitations by law, but they do have numeric requirements end of pipe that they are supposed to be targeting and meeting, and there's a whole exceedance response action process for meeting those. So, would that be left alone, or would the state feel the need to backfill with additional, traditional effluent limitations or discharge requirements, or modify the numeric action level process if receiving water limitations are removed from the permit. And that is a big open-ended question currently that we just don't know the answer to.
And it's interesting that you're raising it. This is actually very similar to a conversation that's reflected in the Supreme Court's transcript, where they're talking about, one of the reasons why receiving water limitations makes sense is in these contexts of general permits, right? Where you may not know everything about a particular construction site or a particular industrial site, but we know that generally, if we fit within these parameters and we protect the receiving water, that we can let them go ahead and do the construction activity or do the industrial activity. And so, one of the comments that the EPA attorney, Frederick Liu, was making is this idea of we allow that because the alternative is you have to get a lot more information from those dischargers, right? To know what it is that they have on their site and then formulate the effluent limitations. So that would be the benefit of keeping the receiving water limitations. That was certainly the pitch that was made at the Supreme Court. But I agree with you. Like that's
Yeah.
what we're going to see play out.
Yeah.
So I'd like to transition us with an observation, which is that I spoke to some prominent stormwater attorneys who I'm not going to name, and they said the one thing that we don't expect is that the state board will make this interpretation of 402B being different. Nobody on this call, and so that's exactly where they went. And some of the stormwater community was nervous about that because they're worried about effluent limitations being a more difficult replacement.
Yeah.
But that's where we stand. The one interesting thing about this is it's up to the state when they're issuing a permit, but there's 50 states. And we're going to see, I don't see Texas coming up with the same interpretation as California, and it's going to be very interesting. It's going to get litigated. So if this is the way we're going to go, although I can definitely see why people are making arguments that the MEP standard and the MS4 is different, and I can see the arguments why it's just the same. We have the same issues with the permit shield. We have the same issues with multiple dischargers that Justice Alito was talking about. But the stormwater community is very much saying that we're different. And this gets us into some current litigation issues. We're not going to talk too much about people's positions on these, but we're going to give you the state of play here. And I think, Nicole, you're going to take this one, right?
Yeah, I'll start this one off. The case that I'll talk about is actually a case that my law firm partner is involved in. City of Mountain View and Sunnyvale, they are municipal stormwater, and San Francisco Baykeeper had brought an action alleging noncompliance with discharge prohibition and receiving water limitations. We won't go into the ins and outs. It is a pending case where it's been to trial, and the decision is pending. But there was a sub motion for reconsideration practice that has resolved now that I think folks need to be aware of, especially if you are a permittee. Most would assume that with the City and County of San Francisco case, that should you be a permittee and you have the receiving water limitations that were subject to that case, that you would believe that they would be unenforceable until the permit is amended and the Regional Water Board may or may not try to continue to impose them under state law like we spoke about. But for now, that they would be, as the Supreme Court seemed to intimate it wanted, that they would be unenforceable and not authorized by the Clean Water Act. So what happened in the case is when the City and County of San Francisco decision was issued, the cities of Mountain View and Sunnyvale filed a request to be able to file a motion for reconsideration and to say to the court the receiving water limitations that are essentially the significant component of this case have been determined to be unenforceable by the City and County of San Francisco case. Therefore, we think that those claims should be dismissed. And without getting too much into the weeds on all of that, what you should know is that part of the objection to that motion involved the state requesting to be amicus in the matter and filing a brief. And their brief was in support of an argument by San Francisco Beekeeper, which said that in the pending enforcement action, so when you have an active case that's being enforced, whether it's the state or a third party taking an enforcement action, that the discharger is disallowed from essentially collaterally attacking the underlying permit limitation that is being sought to be enforced. And so what the state said was, you can't consider the city and county of San Francisco case. That would be a collateral attack on the underlying provision of the permit. That's not at issue here. The proper place for that to occur is the dischargers should go to the water board and either appeal their permits, request reconsideration, the processes for getting your permit amended, and that until or unless that permit is amended, the provisions remain enforceable. And the court issued an order that agreed with that position and dismissed or denied the motion for reconsideration and said, you can't collaterally attack the permit, even though the Supreme Court has said these provisions aren't enforceable. That the court's position was that until the permit is amended, I'll continue to hear this case as to whether or not you did or didn't violate them and have liability, which when you're the discharger in that circumstance feels pretty unfair, that the provisions are illegal, but that somehow you can still be determined to be in violation of them. Now, we have the wrinkle of that case is an MS4 case, and you've heard in the previous sort of session that there's some questions as to whether or not receiving water limitations are not going to be able to be retained in permits. But setting that aside, let's just say you're a wastewater treatment plant, and it's really clear from the state guidance that remove the receiving water limitations, that you could get an enforcement action until that happens, and those provisions might be able to be enforced against you, even though there may be intent by the regulators to remove them and to, implement action as a result of the city and county of San Francisco case. So folks need to be aware that that's the case, because I think a lot of permittees might assume that they don't have to worry about, an enforcement action with the receiving water limitations post city and county of San Francisco. And it is a word to the wise that if you are concerned about that circumstance, that not that the water boards don't have anything to do, and we have a backlog of permits for lots of reasons right now, but to go work with your water boards to talk to them about either individually modifying your permit or collectively dischargers working to talk to the state water board about maybe a more programmatic way of handling what to do with receiving water limitations that they intend to remove. They intend to eliminate the enforceability over time. But what do we do in the interim in order to achieve sort of fairness and with the system that it could expose folks to liability for provisions that really shouldn't have been in their permit in the first place. So I highlight that case as sort of one of the just yet another practical issue that we're dealing with in response to this case, and for folks to think carefully about their own circumstances and whether or not they talk to their regulators, and whether or not there can be timely responses, who knows, but to talk to their regulators about how to handle enforceability going forward, especially if you fall into the category that is, I would say, maybe less contested or controversial right now of like a wastewater treatment plant or something, where I think the state is acknowledging the city and county of San Francisco case sort of clearly applies.
One thing Nicole mentioned is that both of these cases were this collateral attack issue, right? Both of these cases involved a situation where you have a permit, it's adopted, and later somebody's enforcing it, and you're coming in and saying, oh, but that permit isn't valid, you can't enforce it against me. So both of those cases involve that situation. I think Nicole's advice that you should talk to your regulator about the terms of your permit is probably the best advice you're going to get out of this whole 2 hours. So the other situation I'd like to just raise is thinking about the factual differences of these cases, right? So in Sunnyvale, you had an MS4 system, which is a stormwater system, but the key issue had to do with exfiltration from the sewer into that system. So the stormwater system is governed by one permit. The sewer system is governed by a different permit. The stormwater system's permit says you can't have non-stormwater in this system. So when your sewer is going into that system, that's a violation of the permit. So whether or not you have a receiving water limit is going to be irrelevant. You still have a permit term that somebody is going to be able to enforce. And similarly in Tacoma, you have this industrial site. And on this particular site, the allegation said something, huge discharges of, I think it was copper, zinc, that type of thing. The permit required that you implement stormwater controls across the facility. So again, if you have an end result provision that says don't modify the receiving water, don't impact the receiving water, it doesn't matter. You still have this provision that says you have to implement stormwater controls. And if you have huge discharges of copper and zinc, it's clear you're not abiding by this permit. So I just want to point out that we talk a lot about the receiving water limitations. We talk a lot about, what is the impact going to be? And this is going to shake up the world as we know it. And I would argue, no, it really doesn't. That permit terms are intended to be protective. The types of terms, certainly in these two cases, that were being violated, sure, maybe you have a receiving water limitation argument as well, but there's other permit terms that were clearly at issue in those two cases. So again, I kind of come back to, I don't think we're going to see, huge geologic shifts in how we write permits, in the terms of permits. But Nicole's advice is absolutely 100% correct. If you are concerned that terms of your permit leave you opened to potential citizen suits for something that you absolutely can't control, yes, you need to have a conversation with your caseworker and talk about rewriting those permit terms. But be aware that they're going to want a permit that is protective. And if they can't get that protection through a receiving water limitation, you're probably going to see it through a monitoring requirement. So those are kind of, which would pick your poison, I think.
Yeah. I have lots to say about exfiltration, but I'm going to keep my mouth shut because it is a pending case. But once the court decides, then we should have a follow-up and talk about that because there's lots to mine there.
I don't think that there's a way that we could not have a follow-up given the number of wicks that we were seeing being lit right now. I'm gonna go around, Robin, and ask you all in like 1 minute, what's a key takeaway on this? And then we're gonna go to questions. So I'm gonna start with Nicole. And what's your takeaway for the attendees today if you have a 1 minute version?
Know your permit. Talk to folks who are working in this arena, whether it's through trade associations, whether it's through your friendly neighborhood lawyer. If you're confused, if you don't know what this means, if you are unsure what your permit means, I think right now is really key time to educate oneself because there's so much potential regulatory change that if you don't understand some of these conscripts to start with, it's really hard to figure out what your best solution might be at your facility. So I'd say gain as much knowledge as possible currently that will then help you make good decisions in the future.
All right, I'm going to go to Esty. You have the Drake meme to rely on if you want to.
Fair. I'll just sort of riff off of what Nicole said there, and it. In addition to knowing your permit, I think it's really critical to know your permit timing because folks might not realize that NPDES permits expire in a 5-year time frame. And so typically, as long as you submit your paperwork for renewal, your permit is going to be administratively extended. But what that means is that if you're in that time frame of, it's administratively extended, the water board or the EPA can't go and make this like one isolated change to fix this, so, end result provision or receiving water limitation issue, and they would need to renew the entire permit. So knowing your timing on your permit is really critical. If you want to just focus on this issue, you need to get in there before your permit is expired. So the especially with everything Nicole talked about as far as the enforceability, we're sort of, in my view, midstream of what the implications are here, because if the provisions are invalid but enforceable, we're kind of halfway in and halfway out. So, but there's ways to um, address it, and I think from a from a permit holder perspective, having clarity on what our permits mean and having them say what they mean and mean what they say, and being accountable for that, I think is really the outcome that we're wanting, and we're um, sort of going to have to see how that plays out in these different contexts. And I think being in a combined sewage realm, as Tamron was pointing out, does provide some uniqueness, and a little bit straddles some of these stormwater versus wastewater issues. But I do think these takeaways can apply to most permit holders.
Invalid but enforceable is, we should have called the talk this. It's a juicy way of setting up the problem. I don't see that the federal courts are gonna like that outcome, but they seem to be to date. And Tamarin, what's your 1 minute takeaway?
So I think we originally titled this slide, "Where's the most bang for your buck?" Or maybe there's another slide that says that. And I would say um, everything that SC Nicole said about know your permit, know your regulator, know your caseworker. One of the things that I advise clients is have your regulator come out to your system, whether you're an MS4, whether you're um, a wastewater treatment system, collection system. Have your regulator come out and walk through what are the problems with your system. Talk to them about potential violations. Talk to them about your source control issues, and then take advantage of public funding. I mean, this isn't something that this was designed to talk about today, but there's a ton of public funding out there, even with the budget cuts federally. State of California is doubling down with I think it was Prop 4, wasn't it? The climate change bond. So there is a ton of money out there that can be used for stormwater systems, that can be used for your wastewater infrastructure. And I would say go out and talk to other systems who are doing a great job. Orange County Water District is one of the flag bearers of folks who are ahead of the curve in terms of tackling what their wastewater issues are. And then, of course, recycling that water, finding places for your stormwater to go that it's not creating problems. San Francisco's in a bind because they do have this built up system. They do have a lot of concrete areas and not a lot of places where they could go and just infiltrate things. So one of the things that's so interesting about San Francisco we didn't talk about today is that they're working on a variance, which is to say they're approaching with the regulator a whole different way of being able to allow certain types of discharges, and hopefully doing it in a way that will be part of the negotiations, of course, and the variance adoption, doing it in a way that remains protective. But those are the types of things that you can approach your regulator about and hopefully cut off 10, 15 years of litigation in the process, save that money and put it into your system.
Thank you so much. I'm gonna keep you on screen, Tamarin, because you're gonna be up here for questions. We have some good ones. Some of them are inflammatory, and some of them are inflammatory on both sides of the same issue. So I think it'll be interesting.
Start with those, Fern.
Yeah, I'm not going to read them directly. I apologize to some of them on some of the cases. But to start off with, one of the interesting things in the case Esty and Tamarin, but I'll start with you, Esty, is the ocean side versus the bay side. And Justice Alito makes a lot in the case of the fact that effluent limitations or limitations rather exist in a world of other dischargers. And Justice Barrett comes back and she says, yeah, but this is different because you've got this big pipe 4 miles out in the ocean. What are you even talking about? She wanted to treat it as she would have liked it if it was an arbitrary and capricious claim instead, and said, your multiple discharger issues don't really apply there. But what do you say? If anything, you don't have to say anything. I'll turn to Tamron if you don't want to, about the idea here that there was one pipe out there in the ocean. So do you really not know how how water quality standards are gonna be met on that side of the city?
And that was actually exactly the point that the EPA attorney made. Esty, can you remind me, is the Bayside permit issued jointly with EPA, or is that only a San Francisco Bay? I just don't recall.
It's issued by the Regional Water Board.
Only.
And yeah, just like all the other permits, it's subject to EPA approval.
Right. So
Yeah.
earlier you made the point, we were talking about the distinction between the combined sewer permit, that language, and the language of most of the permits of San Francisco Bay. And you pointed out that it was an oversight or something, and I'm suggesting that there might be an alternative explanation for the difference in that language.
Yeah, that might be. Um, yeah, and I will respond to the comment. I think it's a fair concern, to say that they're, what other source may there be, but the we see trash washing up on San Francisco's beaches, all the time. The water doesn't just stay static, it moves all around, and there's ships and other things, so I don't think it's a fair assessment to say San Francisco is the only discharger to the Pacific Ocean. So it the the Bayside, where it's much more visible of having numerous dischargers to the same bay, is a little easier for folks to identify with in terms of the overall concern, but the concern was there regardless of whether we're oceanside or bayside.
Tamron, do you have anything to add? I don't want to, we're not going to relitigate the case, but we are gonna, if you have anything to add on this, I'd love to know it.
So you're going to have to be more specific about what you'd like to add on. Do you want to talk about arbitrary and capricious? Or do you want to talk about this idea of whether there's this, nexus or causal connection? I mean, I think this is sort of something that anyone enforcing as either citizen provision or EPA or water board is going to have this same challenge, right? So factually, when you get into a court, you're going to have to demonstrate that something happened, right? So whether you've gone out and you've done your own sampling and you've connected the dots because you've looked at the effluent, and the effluent looks the same as the receiving water, and you say these are the same things, this is coming from the same entity. I think that's in practice, it's something that an enforcement entity, person, citizen is going to have to overcome. So this idea of it could be anyone, I think that's a little bit far-fetched. That it's not just anyone, right? There's signatures that come from particular types of entities and the types of effluent that they have. And so I think that's what the EPA lawyer was saying, particularly about the deep water outfall, is we know who this is, right? There isn't a lot of question about who is discharging out there.
I think that's an interesting point because it goes maybe against, and I'm just going to offer this potentially against your other point, that this is really specific to CSOs and combined sewers. Just because I think that the Oceanside plant is fairly unique in Northern California and in California. And the permit terms are slightly different, and you normally do have these situations with other dischargers in California. You rarely have just like one discharger into a water body. So does it matter? I mean, I guess you could try to beat up San Francisco for relying on the Oceanside pipe and making an argument about multiple dischargers. And I think Esty maybe responds, but my position would probably be, it has broader implications. But I know we have disagreements on that. I think it's interesting. One thing I wanted to get at is cause or contribute. And some of the origins there. Nicole, I don't know if you want to talk a little bit about just why historically there was different language and how that arose. It's an interesting issue.
Sure. So we have inconsistent application throughout the state depending upon the permit as to whether or not NPDES permits say cause or contribute or cause. Obviously, the federal regulations have the language of cause or contribute, and that's obviously the origin of that language. But a number of years ago, the State Water Board had undertaken the effort to try to streamline and make NPDES permits consistent throughout all the 9 regional water boards, as you could imagine. If everybody's using all their own versions and different staff folks who are using their different versions, it became really difficult for the Office of Chief Counsel and for the state to sort of keep that QA/QC of NPDES permit terms. So the Office of Chief Counsel, along with State Water Board staff, had created an NPDES permit template for the water boards to use. And this was probably 15 years ago. It might be longer. And in that template, the contribute was removed, and it just says cause. Not all NPDES permits have followed that template. So we see it a lot in individual NPDES permits for wastewater treatment plants, industrial process water. You see a lot of permits that just have the cause, but in a lot of the stormwater permits, it still says cause or contribute. So the origin of where the permit came from, did it go through permit template, which staffers were working on it, what was the timing of sort of the origin of the permit, all of that plays into why we have inconsistent receiving water limitation provisions. And the difference of that word contribute can be substantial in terms of potential liability, because obviously cause is a clearer, more specific standard, whereas contribute, everybody gets worried about that one molecule. Everything could be a contribution. And so what we've seen throughout the state is, quite frankly, inconsistency on permits. And so some folks don't have to contend with contribute and some do.
And inconsistent application of cause or contribute with the one molecule.
Yeah.
The one molecule
Agreed.
or one cell, argument was mentioned in the briefing in the Supreme Court. It gets raised every once in a while in the wild. I don't know how often it's been actually litigated. You could comment on that, Nicole, but it's one of the more compelling cases about why these standards are vague and should be more specific, I think. Do you agree with that?
Yeah, I think cause can still be rife with the same risk of the generalized provision, and how is that assessed, and consistency of assessment, especially if you have a situation where you may not be in the smaller dischargers, certainly like an industrial stormwater discharge, they may not be directly discharging into the receiving water. And so let's say they discharge into the MS4 along with everyone else, and 10 miles down the way, it hits the receiving water. How do you assess cause? And what has occurred with case law in, say, the industrial stormwater permit context over the years was a couple of courts sort of throwing up their hands and saying, well, all I have is discharge data. And so discharge data is being compared to receiving water standards for purposes of assessing compliance with receiving water limitations. And from my perspective, that is absolutely not technically correct or accurate. You need to have upstream discharge and downstream data to assess compliance with the receiving water limitation. So even with that cause language, although it could be better in certain circumstances and might reduce risk in certain circumstances, It's still not helpful in others. It's not enough to, sort of minimize and mitigate the risks that we're talking about in terms of then deferring back to, well, let's just compare your discharge with the water quality standard. And if it's above it, you're sort of automatically in violation of receiving water limitations. And I think that's been one of the core problems that we've seen over the years, which is why folks are seeking to remove receiving water limitations to avoid that outcome. Because, I'll just use a simple hypothetical. If your water quality standard is 10, and your upstream water quality is 2, and you discharge 12, but the relative contribution from a volume standpoint, maybe you're a very small part of the watershed when you discharge, maybe that water body downstream is now at 2.2. Did you cause an exceedance? Well, if you truly have the right assessment, the answer would be no. But if all you're doing is comparing discharge data to water quality standards, your answer would be yes. And so that's part of the big problem with receiving water limitations, especially in the stormwater context, is it's sort of an imperfect way of assessing, and what it does is it a lot of times sweeps people into liability where they may not technically be liable. So that, I think, is the continued struggle. We've talked about sort of, there's pros and cons to receiving water limitations. Are effluent limitations going to be more difficult in certain circumstances like MS4s? Is it better to have effluent limitations or receiving water limitations? There's no perfect answer. I guess I'll leave the group with that sort of issue, that it's going to be fact specific for each sector as to what ends up being sort of more preferable. And it'll certainly be fascinating to see over the years how this all is implemented.
All right. Okay, so I don't know if we're going to answer this question or not because it's mainly because of expertise, and I don't want to be the only one who answers this question. But there's inflammatory questions on several sides of what about unfunded mandates, and that could be unfunded mandates generally with respect to these requirements. Tamron, you've actually written a little bit about this, although I don't know if you want to get into it in detail, just the background of how much litigation is going on and how the challenges are working.
Right. So MS4s this is what we're talking about, is stormwater permits were adopted, and they were municipalities challenged those with the commission on state mandates and basically said, these permits require us to do things that other dischargers don't have to do. That is only because we're these governmental entities. And so therefore, this is a state mandate, and the state should therefore have to pay for the types of things that we are required to implement. So I'm very broad brush here. So this has been challenged. Let's see, I want to say it's in the San Diego region, the Santa Ana region, the Los Angeles region, and the San Francisco region. And I did have the pleasure, the very great pleasure of writing briefs to the Commission on State Mandates about this issue. I don't actually think that mandates going forward is really going to be an issue. The legislature made it pretty clear that the types of requirements that are in those permits, those are fee-funded issues. So I would like to think that going forward, those issues should be put to rest. With respect to past permits that predated that legislation, people are going to litigate because that's what they do. If you want my own opinion about where to put your bucks for the most bang, I would go back to source control. Start working with your regional water board caseworkers, figure out your system, figure out where your problem areas are, and then attack it with public funding. Measure W in Los Angeles, I think it was Measure AA out of the San Francisco Bay region, hugely effective in terms of getting public dollars to actually fund those endeavors to build more better stormwater controls. So I think as far as the city of San Francisco case goes, I don't see it impacting MS4s or unfunded mandates at all. And my advice to deal with both would be the same, which is talk to your caseworker, go get some money, fix your source control.
All right, I'm going to fill in the gaps a little bit there, which aren't many. They're mainly a difference of opinion, but the law that Tamarin is referencing is SB 231, which attempted to unwind a Court of Appeal decision that said that you couldn't do stormwater fees as property-related fees. And the result was it became much more difficult to do such stormwater funding without a vote of the people and a 2/3 vote. City and County of San Francisco has been involved in litigation sort of related to this. I would refer people to the Gluck case, which indirectly has to do with SB 231. But it's a super complicated issue in which first you start with the issue that Tamarin raised about whether or not there are any unfunded mandates anymore in the context of stormwater. And then you get to the issue about whether or not you can charge fees for it and whether or not it's a federal mandate. And I do not anticipate litigation on that issue going away, but I do agree with Tamarin that that's the state's position to date. So several questions on that, though. So it's an interesting issue. I know it's of particular interest to the local agencies here. Another question, we're running out of time, but another question is about Region 9 in San Diego released a tentative NPDES permit that removes receiving water limitations from the permit, but includes a general requirement to fully comply with the ocean plan and basin plan through 401. All receiving water limitations that were removed from the permit are contained in the ocean plan and the basin plan. Clean Water Act 401D mandates that 401 certification conditions become conditions of the underlying permit, effectively reincorporating through 401 certification the same receiving water limitations that cannot be directly adopted in the NPDES permit. Do any of you have thoughts on the interplay between 401 and NPDES permits and the San Francisco? I'll leave it there. It's a complicated question. I actually have not looked at that permit, and I don't know if any of you have comments on that.
I haven't looked at this permit either, and I would say that's pretty creative. I'm not sure. Usually you see 401 in the context of dredging activities, so I'm not even following where they make the link on that.
I'll put a plug for one of our conference sponsors. I have looked at this permit, and NACWA, which is the National Association of Clean Water Agencies, and then one of our conference sponsors, CASA, California Association of Sanitation Agencies, actually submitted comments on that permit back in October. Obviously, that's a public document. It was submitted to the Water Board. And Vern, I can send you a copy of that letter, and to the extent folks who are attending here would like to see what those comments were, you could make that available, and that might be helpful to anybody who's interested in what's going on there.
Yeah, I think that would be great. So I will include those comments in the materials that we send out afterwards, along with the slides. A broad policy question, which I think might be our last one here. What policy rationale, as opposed to technical legal argument, and it's attorney asking this question, so I love it, can be given for regulating municipal stormwater more stringently to meet water quality standards under the MEP standard than individual wastewater point sources are under BCT and BAT? I think it's a rhetorical question in part. And we may treat it as that unless you have another comment.
I think it's a interesting thought exercise, right? And I think that's probably why the way the question was asked. So because we're sort of in that place where the, you know, law and the operational realities and the um, regulatory structure are trying to find how they all fit together. So I do appreciate the question for the thought exercise.
So I'm gonna take a shot at this one, which is to say the question is what policy could justify having more stringent regulation of stormwater versus individual? And I would say both the Clean Water Act and Port of Cologne, the policy is under the Clean Water Act, we're going to have no discharges by 1986. And under Port of Cologne, we're going to have fishable and swimmable waters by 1983. So relatively similar goals, right? And if you have a stormwater discharge that's creating a really truly toxic environment versus an individual permit that really doesn't have a huge impact on the quality of the water, yeah, I could definitely see why you would, as a policy matter, want to regulate the one more stringently than the others. So I think that's an as applied issue, maybe.
Anything on that, Nicole?
No.
Okay, good. Um, one other question I have, there's language in this case that I just don't know how far it's going to go and whether or not it's just a Supreme Court justice who really doesn't know about how people on the ground really are working through some of these issues. And it says, there's a distinction between within and without. And it says that a limitation is something that comes from without, meaning that it's imposed. And it says the direct source of restriction or restraint in the case of the San Francisco version is the plan that the permittee imposes on itself for the purpose of avoiding future liability. And that's something that is bad. You need something where it's actually the regulator who figures it all out and imposes it, as opposed to the regulated entity figuring it out. We have lots of plans in NPDES permits, right? I mean, lots and lots of plans. So is this a one where we're just going to have to see if this has any legs?
Yes, I think everyone, it's going to take at least 6 months for people to even absorb what within and without means, because when I read it, it seemed like it should be the opposite. But I think the Webster's dictionary was the source of all of that without, within fun. But yeah, I think that's right.
The point I think is curious about this, that's actually not raised in this case at all, but it is curious for California practitioners, is that the water code actually places a restriction on regional water boards. And Vern, you and I talked about this before, this idea that the water boards cannot dictate the means or the manner of compliance, and it's Water Code Section 13360. So it's this question, which I thought was kind of entertaining about San Francisco's perspective throughout the whole case, which is this idea of tell us what to do. We don't know what to do. We need more guidance. We need more direction. And I'm thinking, well, that's going to be interesting to see how that plays out in California, because you do have this conflicting provision that says you can't tell me what to do. So there are, of course, exceptions to that. And I think water boards get around it by effluent limitations, right? And monitoring. So I think that particular text has perhaps different implications in California than it might in other states.
Yeah, and I would argue that the manner of compliance provisions that you were just referencing in the water code are more about specifying the manner of compliance. I think the city is saying, tell us what we're supposed to meet, end of pipe. We'll figure out how to get there, which would be the prohibited manner of compliance, but at least let's agree on what the specific goal is so that we can know whether we are in or out of compliance at the end of our pipe, as opposed to being subject to whatever may be in the water from whatever source. So I think the manner of compliance issue can still be separated.
Well, and SD should certainly pipe in on this. But interestingly, I mean, San Francisco is subject to this long-term control plan requirement. So when you say, tell us what we're supposed to be doing, it's a planning requirement. So, again, it's sort of a different, unique animal when it comes to San Francisco.
We are out of time. I appreciate the panelists and their insights on all of this, and want to thank all of you and thank of all of the attendees. This was recorded and will be available online. I know a lot of people have asked for it who weren't able to come, and I'm grateful for the interest in the topic. So thank you all, and we're going to wind it down now.
Thanks, Vern.
Thank you.